Mr. Jacobus, he's helped us out a lot with getting it on schedule and everything like that. And this orientation is basically going to be explaining what we're going to be doing here, what's going to take place and what needs to be done before we get started. And with that, I'll let him go ahead and do.
Well, good evening. I've already met a lot of you. I won't remember the names, but welcome. My name is Jay Jacobus, and I'm an attorney in Ridgeland, Mississippi, just north of Jackson. I grew up in South Mississippi. I went to the University of Southern Mississippi. I grew up right outside of Hattiesburg. Went up to Mississippi College Law School, mainly so my wife could get a job to kind of put me through law school after we graduated. And she works for a big law firm in Jackson, Baker Donaldson. She's the manager of their health law department for them, a non-lawyer. But we do a similar type boot camp at MC. And so a lot of my friends down there ask me, why are you going up to Oxford to do the same thing, especially when we're going to be competing against those people? And they know because of NEDA, I love teaching trial advocacy, and I'll do it anywhere, anytime, any place. I've taught over 50 NEDA or NEDA-based classes, programs, all over the country. I've even been to Myanmar, the country formerly known as Burma, for 2 weeks to teach Burmese lawyers how we do things in the U.S. I get to go to San Diego on the even years and Canada, usually Montreal, Toronto on the odd years to teach at a big law firm up there. Over 700 barristers in that firm. 95% of their trials are bench trials, but they like to hear from American faculty. They like to see how we do things because we typically think outside the box. We go over the edge a little bit. They roll their eyes a lot, but they enjoy having us at least. They keep inviting us to come back. But I've had the pleasure of teaching trial programs at, of course, Mississippi College Law School. I did LSU Law School for 17 years straight from 1998 to 2015. We're going to my second year at Emory Law School, where they bring in 95 faculty for a week-long trial advocacy class. That's in May. I just spent a week in New Orleans a week ago for the NEDA Gulf Coast Regional Trial Program. Those are typically reserved for attorneys that come in that need help. A number of them have sat first or second chair in their trials and never a first chair position. And so they're coming in wanting to hone their trial skills. And so the first thing on here is why. I got a call from the dean and basically explaining that, look, we want to improve our trial advocacy program at the law school. It's something that's been lacking for a few years. We think we want to go ahead and invest the time and effort to do it. And if you'll help with this initial program, then we're going to evaluate and see where it takes us. And I told the dean, I said, I'd be more than happy to. I've really enjoyed working with these guys. They've been great. We've had a lot of emails, a lot of phone calls. I've been up here. This is my second time to come up, trying to get this thing going. And let me tell you, it's an abbreviated schedule, and we're going to get into it on what we're talking about. But if you're going to end up going through this program, it's something that you will truly enjoy. I can assure you of that. It's intimidating at first, but I can tell you it's going to be fun. The NEDA method. Now, if you haven't heard of the National Institute of Trial Advocacy, this is something that started probably back in the 60s or 70s when then Chief Justice Warren Burger of the Supreme Court of the United States basically said, you know what, trial lawyers in the United States suck. And that's, he didn't quite say it like that as the Chief Justice, but he meant that people don't know what they're doing when they get into courtrooms. And so NEDA was formed. It's out in Boulder, Colorado. I'm fortunate to get to go out of there, get there maybe once, twice a year to teach in Boulder at NEDA sponsored programs. A number of law firms will basically pay large sums of money to NEDA for their lawyers to come, their young lawyers all over the country to fly to Boulder. And then they go and they attend usually a 3-day deposition course or a 5-day trial advocacy course. So the NEDA method is learn by doing. And the reason that's so important, you can look at this and this is going to tell you, when you talk about the learning pyramid and you talk about the retention rate of what we retain as we learn, if you'll just start at the top, you'll see lecture, reading, audiovisual, demonstration, going on down, discussion group, and then look at that, 75% retention rate on practice by doing. And that's why NETA is separate and distinct from any other teaching program in the country, is because the NETA method requires the participants to get up on their feet, to think outside the box, to get outside of that area that they feel comfortable with and perform. And they have to perform not only in front of the faculty, but they have to perform in front of their other participants, okay? Now, the great thing about NETA is that we have trained NETA faculty. And let me tell you, we go all over the country together and teach. And that's the great thing. When I go to Canada last October, when I got up there, I was with a federal judge from Texas that comes every other year. I was with some outstanding litigators from Texas and other states. And I see them every year, and we teach together, and we have been teaching together at that program since 2007, every other year. And so this is a situation where we know how to basically feed off of each other on how we go in and offer something that we call critiques. And critiques are a little bit different because none of you are going to get any criticism. If you end up in this program, you're not going to be criticized for your performance. You're going to be critiqued. Now, the deliberate practice theory, if we take a look at this, just repeating a skill or task, even over a period of many years, it will not build expertise, okay? And so you've got to do something a little bit more than that. Deliberate practice involves stepping outside of your comfort zone and trying activities beyond your current activities, okay? This is where everybody's going to be up for an Academy Award in this particular program. I mean, that's how we want people to think, is to be dramatic. Think about those TV lawyers. You've all probably got somebody who's your favorite TV lawyer, but this is what we want people thinking about. An expert breaks down the skills that are required, focuses on improving those skill chunks during practice. And so that's what we're going to do in this program. This is how we're going to get our points across on how to go in and basically master the basic trial skills, okay? This is a program that starts on a Friday afternoon and it will end on early Sunday afternoon. And so we've got a limited amount of time. When we do a full-blown week-long trial, like I did in New Orleans recently, we basically start with openings, then direct cross. We do a little impeachment. We lay foundations. We do not jury selection, but jury deselection. We bring in an expert from Texas who basically was the jury selection consultant for the Boston bomber trial, Dr. Jan Jacks. They bring in a communication expert who basically helps everybody on nonverbal communications. What's distracting to a jury? What are they going to look at? You know, what if you look at the ceiling, or you look at the floor, or you don't look at the jury at all? Maybe you have a tendency to start everything with and or so. And so David Mann comes in from the great Midwest, and he comes down and he talks every year about nonverbal communication. And unfortunately, we're not going to have the time to do all that, but the way I see it, the sky's the limit. At some point in the future, maybe we'll get there, okay? Learning environment. This is what we're going to do. You're going to have myself, we're starting off bare bones, and so what I've done is, in order to stay within the budget, I've invited one of my teaching friends. Her name is Mandy Barton. She's a construction litigator out of Fairhope, Alabama. She's actually an Ole Miss Law School alum. And when I called her up and asked her, she said, yes. She said a little bit more than that, but she said, absolutely, I'll be happy to come. So it'll be Miss Barton and myself will come, and we will basically be the one helping you, giving you the support you need to go through this program. This is crucial. This is what we tell every participant at every NETA program. Don't judge yourself or compare yourself to others. And when I was in NETA just a week ago in New Orleans, this is what we told those young lawyers. Some of them were very intimidated. We always at least have one. We try to have 30 to 50 participants in every regional across the country. We only had 31 this past year, but we always have one that gets up, runs out of the room screaming, crying, because they get out of their comfort zone. And they need to have that kind of hand-holding experience that we can basically make them find their style, not necessarily adopt somebody else's style, because you're going to get to see a lot of different styles on how people perform when they get on their feet. And the way they do things may not be best for you. And that's one thing that Ms. Barton and I are trained to do, is to evaluate somebody's own litigation skills, what they're good at, how to improve that even better, but how to find those areas where they need improvement and raise the bar on those areas, okay? So when we go down and we teach in New Orleans, we tell people, look, don't judge yourselves, don't compare yourself to others. What happens in NETA stays in NETA. What happens when we teach this boot camp is going to stay in the boot camp. I'm not going to go and tell any of your professors, any of the administration, any of the faculty, nobody at all will hear about what we did in this program. And just like at LSU, that was a 3-day pass-fail. You had to come in a week early. People were bitching and complaining about having to come early. They said, I'm going to be a patent lawyer. I'll never step foot in the courtroom. And funny, they come up on Wednesday and say, you know what, I think I'm pretty good at this. I'm thinking about a career change. And that's what we want to do. Even if you don't become a litigator, there may be a time where you have to be an advocate, where you have to get on your feet and express a certain position. It may be an administrative hearing in workers' comp or someplace else. But you're going to have the opportunity to get the confidence of standing on your feet, exerting a position, be an advocate for your client, and that's going to build confidence. And that's part of this program. So we don't want you to judge yourself or compare yourself to others. Again, it's critique, not criticism, okay? It's going to be constructive critique, okay? We're going to basically, and NETA's got a way that we go back and we do something, we give a playback. And a playback is, okay, what you did is on cross-examination, you just ask an open-ended question. And that's gonna hurt you every time. So what I want to talk to you about is, I want to talk to you about leading questions on cross-examination only. Not necessarily asking a question, but making a statement and having an inflection at the end of that statement to where that person on the stand is going to either say yes or no. And so that's how we do the NETA critique, okay? We basically go in, tell you what you did and how you can make it better, okay? This is not a competition, okay? You will have already been to the competition, okay? This is a mental challenge for everybody. And the great thing about this program is we're going to teach it using NETA methods. So that means it's not only going to help you in your future competitions while you're in school, but it's going to help you when you first step into a courtroom, okay? Because there are very little differences between competition and real world, okay? And so what we're going to do is we're going to give you the tools where you can go in any trial setting and understand what a non-leading question is on direct, what a cross-examination leading question is, how you conduct an impeachment, how to build a theme and a theory for your case, how to weave the theme and the theory in an opening, and then have it come out in the closing as well. And that's what we're going to concentrate on in this particular boot camp. Most thing is have fun. I mean, this is really a fun experience when you get up because you're not being judged. You're not getting a grade. And so all you're doing is saying, look, consider doing this. And then the next time when you get up to do it, we're going to be looking to see if you might have taken that and you're no longer starting your questions with and or so, or you're asking non-leading questions on cross. So we want everybody to have fun. Overview of the weekend. What we're going to start out with, case theme and trial strategy, okay? And I'm going to do about an hour lecture starting off just on what you're going to be looking at in developing a theme for your case, okay? Opening statements. This is something that what we're going to be doing is, and you know, when I typically get up and try a case these days, most judges will give me 20 minutes for an opening statement, sometimes 30, depending on the complexity of the case. The great thing about this is we're only asking for a 6-minute opening from each of you, okay? Followed by a 6-minute closing at the end. So you know what? I can get up and talk about anything for 6 minutes. I don't need notes to do that. So what we want you to do is we want you to think, have the mindset of quality over quantity, okay? If you get up and do an opening in 3 minutes and it knocks our socks off, great. We'll tell you, hey, sit down, you did a great job. This is the only thing that I'd recommend you do to improve. we may not ask for the entire 6 minutes. In the longer NETA programs, one of the things that we do is we have something called video review. And when I go to some of these other law schools that have a little bit extended programs, we will always have the performances recorded. And then we always have, provided we have enough faculty available, to step outside and go through that video. It's called video review. And we basically have a faculty member assigned to look at nothing but nonverbal communication, okay? And I know when I was a student in NETA in 1998, I was a swayer. And I loved to sway. When I would talk, when I'd be up, I would be swaying. And I learned quickly in that program not to sway, because the program director, little short Italian guy named Dominic Gianna, who is still the program director in New Orleans, basically came up and started dancing with me as I was swaying. I've got that on videotape. And so you learn to break bad habits now. And this is the best place to do it. Because I can tell you one thing, I try a lot of cases and I see lawyers on the other side, some that are good, some that are bad, and some that are really bad. And some of them have been doing it a really long time, but guess what? They learned how to do it the wrong way. And they've been doing it the wrong way ever since. And so when I stand up and make an objection, leading, sustained, guess what? They can't turn a leading question into a non-leading question. When you finish the program, you're going to be able to do that. And that's the great thing about learning now, learning how to do it the right way now. In addition to opening statements, direct examination, cross-examination, and impeachment. And what you're going to learn is a number of different type of NETA things that we use. Let's talk about direct examination. This is where we go in and we're going to ask you, before you ever come to the program, to formulate your direct examination questions, okay? They can be written down. The better part is to use bullet points of the topics you want to cover, because you really don't want to get in the bad habit now of reading your questions, because what does that do? It detracts away from listening to the testimony because you're so intent on asking the next question. And we're going to teach everybody that the first words out of your mouth on direct examination is always going to be what, when, why, who, where, how, explain, and describe. And if you start off with one of those words, you're never going to have a leading objection. You're never going to be forced in open court with all eyes on you, once that objection is sustained for leading, to convert a leading question to a non-leading question. You're going to learn right now how to do it the right way. Same thing with cross-examination. It's not asking leading questions. It's making leading statements with the inflection on the end to suggest a yes or no answer, okay? Because what we learn in NETA is the 90-10 rule, okay? And it's reversed. Direct examination, the lawyer talks 10% of the time. Guess who talks 90%? The witness. They're telling a story. You're just the facilitator. You're the one throwing those questions out there, letting them tell the story. Cross-examination is reversed. We control. The lawyer controls the testimony. We talk 90% of the time. They talk 10% because, well, guess what? They're only saying yes or no. That's the only words coming out of their mouth. Impeachment. We're going to talk a little bit about that with regard to the cross-examination lecture that I will give during the program. Impeachment is what every litigator lives for. And I will pick one person out of the audience during the program to act as Mr. James Taylor, a disinterested witness to an automobile accident, who said one thing one day after the accident, and now 2 years later in trial, he's saying something completely different about who caused the accident. And so you'll actually get to see the impeachment and how to conduct an impeachment, when strategically to go in and have an impeachment exercise at trial, because you're not going to impeach on everything. If somebody says the sky was blue and then at trial they say it was light blue, you're not going to impeach on that. But if it's something close to being case determinative, then that's something where it's important enough to where you need to know how to go in and conduct a proper impeachment, okay? Closing arguments, okay? Big difference between opening statement, closing arguments, especially for competition purposes. Because if you go in and have statements contained within your opening statement that the other side doesn't agree with, that's argument, and that's objectionable. That's improper opening statement. And we're going to learn early on how to go in and make a proper opening and then take everything that's come out in the trial, all the testimony, all the documents, everything, and breathe that back into that closing argument. And we're going to be adopting something called primacy and recency. With the theme and the theory of our case, we're going to start in opening and we're going to finish it up in closing. We're going to tie a nice little bow on our case to where that fact finder is going to rule in favor of our case. Okay? How to maximize your boot camp experience. When we go to Canada every odd year, it's amazing. This law firm, it's called Borden, Ladner, and Gervais. They have over 700 barristers in Canada in all 5 provinces. We started out the first 2 times in Toronto. The last several times we've been in Montreal. They're talking about Ottawa and Vancouver now, which makes us very excited for the next year. But one thing that they do is they take a kind of a dog and pony show to every province, at every office in Canada, and they meet with those participants and they tell them exactly what's expected of them during that program, because I can't tell you how many thousands and thousands of dollars the firm spends not only bringing in their senior partners to help pair with the American faculty to serve as the faculty for the entire program, but they're bringing in probably 60 or 70 of their second, third, and fourth year litigators to this program. So they want to go in and educate them and tell them what's expected of them. We do something very similar at MC. We always meet with the participants prior to the start of the program to say, we want you to come in, not necessarily fully prepared, but at least partially prepared enough to where you can feel comfortable getting on your feet that first day and maybe offering up some form of an opening statement, okay? So the first thing we've got something called a case file from NETA, and NETA's probably got 40 or 50 case files that they use all these different kinds of programs. And I guess I've had to learn about 10 different case files because we use one certain file in NETA in New Orleans for our trial program. We have another one that we use for the deposition program in New Orleans in April. Emory Law School uses a different type of NETA case file. Thank goodness the program in Canada uses the same one that we use for the trial program in New Orleans. And then I'm fortunate enough, at least 2 or 3 times a year, to get invited to become part of a custom program. And custom programs are really nice because they pay the faculty. Okay, so when I go to Canada or I go to New Orleans, I get all my expenses paid. They take us out at night, all the drinks, and we drink a lot and we eat a lot. And we have a really good time because we're with all the faculty. But these custom programs are really nice because they actually pay the faculty to go. And so I've had to learn a lot of new case files. But for purposes of this boot camp, I picked one of my favorite ones. And it's one that I actually started with in 1998 as a student in NETA. And when I went to LSU to teach that August, because the program director said, we want you to come and help us teach the LSU program, we were using the same case file. It's called Potter v. Schrackle. And it's an automobile accident case. It's a wrongful death case. Some of you may have heard of it. But it's a case brought by Mr. Jeffrey Potter on behalf of his now deceased wife, Catherine. And apparently, during the course of this day, about 3:30 in the afternoon, at the intersection of Kirby and Mattis in the fictional NETA City, apparently Miss Potter was walking, and at some point she was struck and knocked to the ground by the vehicle driven by Mr. Charlie Schrackle, who is the owner of Schrackle Construction Company. And the main question in this case is, where was Catherine Potter when the impact took place? And as you might expect, in order to make there an even playing field, you've got some witnesses for the plaintiff, some witnesses for the defendant. Some are going to testify that even though I didn't see Catherine Potter when she was struck, she was in the crosswalk, legally within the crosswalk. But then you've got two other witnesses who are going to say, no, she took a right halfway across the street, turned on the median, went south on the median, and then stepped out in the path of Mr. Schrackle's truck. So it's a wrongful death case. And what we're going to do for purposes of this boot camp is we're going to go in and do the openings, closings, direct, and crosses, basically on the liability issue only. We're not going to cover any damages. The case file is about 49 pages long. It includes all the damage components. It's got expert reports. It's got calculations. You don't have to worry about any of that, okay? The only thing you have to worry about is probably the first 20 or 25 pages that contain all the deposition transcripts and the statements given by some of the witnesses. That's the main thing. It's got a complaint. It's got an answer. It's got some jury instructions. I recommend you look at all those, okay? Look at all the pleadings, look at the transcripts, look at the statements, look at the jury instructions. Don't worry about the damage component aspect of that, okay? So that's one thing. Go ahead and read the case file before you get to the boot camp. If you can, if you have time, go ahead and prepare some examination outlines before you arrive. And when I'm talking about outlines, you can use them with a bullet point, procedure to where you go in and you simply have the areas that you want to cover, okay, such as general information, background, education, employment, and then once you personalize the witness on direct, then get into, and we're going to talk about using signposts, okay? Okay, Mr. Potter, now I want to talk to you about the day your wife was struck, okay? So we're going to use signposts for a transitional type feed to get from one point to the next. Develop a theme for your case, okay? This is something that we want everybody to be thinking about, is something, and I'll talk about this during my lecture, but think about if you're, and of course, you really won't know until about a week before the program if you're going to represent the A's or the B's. Everybody's going to be assigned either an A or a B. A's are going to represent the plaintiff, B's are going to represent the defendant, okay? So once you get that, you'll have the case file, you'll have your A-B designation, and you'll have the program schedule. And the program schedule will tell you at certain times, starting with the first day, all A's will prepare a direct examination of Jeffrey Potter. All B's will prepare a direct examination of Charlie Schrackle, okay? So you'll be able to look, digest the materials, think about what you want to ask and what your theme is going to be in the case. Okay, so you want to go ahead and draft some form of an opening and closing using your theme and the theory of your case. Limited use of cell phones and laptops. I can't stress this enough. The great thing about this program is you're going to get out of it what you put into it. And if you come in here, and I know I'm on camera and I know this is going to be showed, but if you come in and half-ass this, that's what you're going to take home with you. That's what you're going to get out of it, okay? And so the main thing is go in and look, it's a really abbreviated time. I mean, you're not going to be on your feet very long, okay? You're going to have to watch other participants, and you'll learn by that because you'll learn by the critique that's given, and then you'll start thinking about critiques of other participants in your own head. And that's why we do this. So limited use of cell phones, laptops, courtroom dress. This is something, and I'm not talking about full suit and cufflinks for the guys. It's one of those things where we feel and have always felt that if you come in dressed in a jacket, a tie, and a pair of slacks for the guys, some business suit for the ladies, I mean, it's one of those things where you're going to perform better than if you came in with camouflage or some kind of different type of swimsuit or anything like that. You're just going to perform better, okay? And like my old high school football coach said, you look good, you play good. And that's what we're going to do in this program, at least for Friday and Saturday. Sunday, I don't care what you wear, okay? Because we're going to be doing closing arguments on Sunday, and that's going to be an abbreviated type. So that's one of the things that we'll look at is dress down, be casual on Sunday. I've talked to the guys that are kind enough to go back to the dean and ask for a little bit more money in order to feed y'all during the program, because we don't want people having to go off campus to eat. And this is one thing we want to have meals and snacks provided. So even sometimes we'll do a lecture during lunch. While y'all are eating, we'll basically be up on our feet talking. And we want to keep y'all here, keep you engaged because it is a very short program. Learn from others we've already talked about, that both performances and the critiques that they're offered, and then feel free to ask questions, okay? We're always happy to take questions. That's basically it from the boot court orientation. I hope to see you all at this program. It's something I think you'll all enjoy a lot. You'll get a lot out of it. It's one of those things where you will not realize what you get out of it until you're gone, okay? And let me give you just a point in chief. I tried a 5-day jury trial in Yazoo City in August of last year. And it was a 18-wheeler minivan accident. Unfortunately, my State Farm insured, and I do most of my insurance defense for State Farm, single owner of a truck, just one truck, one 18-wheeler to his name, and he would go to Yazoo City every day from Humphreys County, and he would pick up a load of sand or dirt or gravel, and he would take it wherever he needed to go. And unfortunately, on this particular day, before he got to the plant to pick up the load, he rear-ended a woman who was trying to make a left-hand turn. Her testimony was she was going 30 miles an hour and was waiting for a car to pass, and she was going to make her turn. My client said no turn signal. She testified, yes, I had my turn signal on. Okay, about $44,000 in medicals. And you're thinking, well, you know, using the old factor of 3, that case is worth about $150,000. We'll admit liability, no problem. Plaintiff's lawyer went in, hired all these experts. Basically, and I'm not saying he got her to testify, but she testified that she can no longer drive. She's basically in her 50s, so a pretty long lifespan to go, but her fear of 18-wheelers made it to where she could not get behind a steering wheel anymore. So at trial, they brought in her attending physician. They brought in a general medicine doctor to talk about her disability. They brought in a life care planner. They brought in an economist to go in and bring all the damages down into present value as they're required to do. And they brought in a mental health expert that talked about the future mental health treatment that she would need to get through the rest of her life. So when it was all over and done with, they put over $700,000 of damages on the board. We had $1 million policy. Their demand initially was $1 million. They never came off that million. I stopped at $200,000 on my offer because they never would come down with a counter. From the time they picked a jury to the time they closed in their closing argument, they asked for $1.5 million, which was problematic for us because guess what? My client's only got $1 million in coverage. He's responsible for everything above and beyond that. So I've got a lawyer on the other side that's been practicing over 20 years. I've been practicing just over 30 years. And so I was thinking, you know what? He's been doing this a long time. Trial ought to go pretty well. Maybe a 3-day trial. Let me tell you, he didn't know how to ask anything but a leading question, even on direct. So I immediately had to start objecting, and I could tell I was turning the jury off. I was basically starting to alienate the jury because they couldn't understand why I was objecting. What is he trying to hide? They were rolling their eyes, shaking their head. And so it's one of those things where I finally got up, and I felt like the judge was going to find me in contempt, and I figured it was probably warranted. But I got up, and my objection was, Your Honor, if Mr. Smith would just preface each of his questions on direct with what, when, why, who, where, how, explain or describe, I promise I won't ask and I won't raise another leading objection. So the judge looks over at me, and the judge looks back at the other attorney and says, Mr. Smith, Mr. Jacobus has just told you how you can ask a non-leading question. And guess what? He still couldn't do it. So to make a long story short, because I know you're sitting on the edge of your seats wanting to know the outcome of the case, they asked for $1.5 million. I told the jury to give her $440,000, basically 10 times medicals, because I obviously wanted to keep it below the million. They came back with a $625,000 verdict. Big win for us, because I kept it under the million. My client had no personal liability because State Farm paid the entire amount. So about a week after trial, this particular lawyer has somebody that I teach with at MC all the time. And I took her aside and I said, you need to tell your partner that he needs to sign up for a NEDA program and learn how to litigate cases. Now, he's probably not going to do it because he's too proud, and I understand that. But the thing about it is, this is where you want to learn, and you want to learn to do it the right way. So again, hope to see you all at the program. I hope you all get in, and we'll go from there.
Thank you, Mr.
All
Jacoby.
right.
I bet State Farm dropped.
They probably did.
So if you just made the team last semester, and for the new members, you're required to take the program, though I'm sure you're excited to. But if you aren't in that category, so you're a 3L or a 2L from the last competition, the spring competition, and you want to participate in the program, let Ian know so that when we're building out the schedule, we know that. Okay, mostly for the people watching. But if any of y'all want to take the program and you're not in the required category, just let us know that so Ian can build the schedule with Mr. Jacoby.
And even if you want to come in and sit in on it too, Mr. Jacoby said that would be an opportunity to play witnesses or whatever.
Yeah, so if you're not going to take the program, we need you to help us play witnesses so that Ian and I can play all that. And then we can cool. Any questions? Thank you. Thank you, Mr.
Happy to do it.
Yeah, and just so everybody knows, it's February 28th through March 1st. That's that last weekend of February.
What's your partner's name again? You said you did the program.
Yeah, her name's Ann.
I'm comparing myself. Yeah, I thought that was pretty funny just because.
That's amazing. Yes, she used to be a third.
That's my cousin. Yeah, Lucas Ernest, Peter Ernest, Filipino all them. Yeah. Yeah. Okay, all right. Yeah, my sister's middle name is Ernest. We took that. Gotcha. Very cool. Yeah, it looks good. Thank you.